Mrs.P.Keerthika, Assistant Professor, Department of Commerce with E-Commerce, Nirmala College for Women, Coimbatore. In this video, we are going to discuss on the topic Cyber Law and its provision under the IT Act 2000. In this video, we are going to see about the introduction of Cyber Law, IT Act 2000, e-contract in India and its types. Cyber law is a term used to describe the legal issues related to use of communication technology, particularly cyberspace, that is, the internet. It is a distinct field of law in the way that property or contract, or as it is an intersections of many legal fields, including intellectual property, privacy, freedom of expression, and jurisdiction. In essence, cyber law is an attempt to integrate the challenges presented by human activity on the internet with the legacy system of laws applicable to the physical world. Next, we move on to Information Technology Act 2000. The Information Technology Act 2000, also known as an IT Act. It is an act proposed by the Indian Parliament, reported on 17th October 2000. This Information Technology Act is based on the United Nations Model Law on Electronic Commerce 1996, which was suggested by the General Assembly of United Nations by a resolution dated on 30th January 1997. It is the most important law in India dealing with cyber crime and e-commerce. The main objectives of this act is to carry lawful and trustworthy electronic, digital and online transactions and alleviate or reduce cyber crimes. Next, we move on to the e-contracts in India. E-contract is the one of the divisions of e-business. It is similar to the traditional business wherein goods and services are switched for a particular amount of consideration. The important factor involved is that contract takes place through a digital mode of communication. It provides an opportunity for the sellers to reach the end of consumer directly without the involvement of the middleman. So, e-contract is any kind of contract formed in the course of e-commerce by the interactions of two or more individuals using electronic means such as email, the interaction of an individual with an electronic agent such as computer program, or the interactions of at least two electronic agents that are programmed to recognize the existence of a contract. So the Indian Contract Act was held on 1872, governs the manner in which contracts are made and performed in India. Next, we have the essential and elements of an e-contract. Under that, first one is offer and acceptance. It is important that the offer has to be accepted. So acceptance should reach the offerer by any method like mail or messages, etc. So the offer is revocable until the acceptance is made. Consideration given by the property should be legal to have a valid e-contract. For an example, selling narcotic drugs is strictly prohibited and cannot be considered as a valid consideration. Next, we are going to the second one, that is lawful consideration. The Indian Contract Act of 1872 reads that in the present scenario, once an item has been supplied and the price has been paid, the consideration is executed and the requirement is satisfied. So problems may arise at a time when the consideration is merely executory. So this arises when the seller's computer has done no more than promise to supply that item. So a key intention that lies behind such promises is, of course, the intention is to be bound by that promise. In other words, the intention to create legal relations. So the contract law cannot entirely apply in e-contract, as in sometimes when an autonomous computer is used. Next, we move to the third one, that is competency of parties. In online contracts, as there is no real-time connections. So it is important to note that there should be a confirmation that both the parties are humans, as computers are not able to enter into a contract. This is very important part of an e-contract, and one should be careful as cases of cyberbullying and online fraud are increasing. Next we move to the fourth one, that is free consent. Consent should always be free. So consent is said to be free when it is not caused by coercion, misrepresentation, undue influence or fraud. When it is certain that these above mentioned elements are present, only then an e-contract is confirmed. So along with these elements, a contract is only possible when there are a lawful object and possibility of performance. The first one is about lawful object. The purpose of such contract must be lawful one. So the court will not enforce contracts that are illegal or violate public policy. So such contracts are considered void. An agreement which calls for the commission of a crime is illegal and therefore void. For an example, a person could not enforce an agreement with another party to burn a house down. Also an agreement that calls for a commission of a civil wrong. So it is illegal and void. The types of e-contracts. First one is click-wrap agreements. So the click-wrap contracts refer to those familiar and long blocks of text that nobody reads, detailing the terms and conditions for using a web-based services, software, etc. So they are called click-wrap agreements or contract because the user typically has to click a button or check a box to indicate that they accept the contract. You will have noticed that click-wrap contract or agreement are less negotiable than shrink-wrap contracts or agreement. That is, they must be accepted for the user to proceed to the next web page or again access to an application, so forth. So essentially, click-wrap agreements or contract create a scenario in which the user is forced to either take it or leave it. So this creates a slew of legal problems regarding the enforceability of click-wrap contracts or agreement. The next type is about shrink-wrap agreement or contract. So shrink-wrap contracts are typically licensing agreement for software. So the name derives that shrink-wrap packaging of the CD-ROMs in which software used to be distributed. In such case, when licensing contracts are packaged along with the software, the contract begins when the user tears open the shrink-wrap to use the software. So the licensing agreement these days are usually not delivered with the packaging and instead show up before installing the software in question. So shrink-wrap contracts, as we shall see, have decided advantage over other types of electronic contract, that is e-contracts, in that their acceptance can be reversed by returning the product. The third one is about browse wrap agreement or contract. So browse wrap contracts are something you have probably seen daily. So they refer to pieces of text on websites that go something like by continuing your use of these services, you agree to the terms and conditions, or by signing up, I agree to the terms of use. So essentially, browse wrap agreements or contracts or such kind of contracts that are agreed to simply by continuing to use the services or continuing to browse the web page which where the term originates. So additionally, the terms of browse wrap agreements or contracts can be viewed usually through hyperlinks. I hope you all understood the concepts and the content. Thank you. Happy learning.